Why your trust might still go through the probate process. A lot of people believe this. They believe that if they have a trust, that their family avoids probate. And most of the time, that can be true. But here's the reality I see as an estate planning attorney. I regularly work with families where a deceased had a trust and the estate still ends up going into probate. So today I want to explain why your trust might go through probate even if you did everything you thought you were supposed to do. Hi there, my name is William Ha. I'm a California licensed estate planning attorney. This video is for general information only and not legal advice. So let's start with the biggest misconception. The biggest misconception about trusts. A trust does not automatically avoid probate. A trust only avoids probate for assets that are properly connected to the trust. Probate is not triggered by the existence of a trust. Probate is triggered by how assets are titled at death. The distinction of that is super critical. So let's walk through the most common reasons that a trust plan still ends up in probate. Number one, assets were never funded into the trust. This is the number one reason, and it happens all the time. A trust exists on paper, yes, but the assets were never transferred into it. So for example, a house is still under the individual's name, the bank accounts were never retitled, brokerage accounts were left outside the trust. When that person passes away, those assets are not controlled by the trust nor the trustee. And if they exceed California's probate threshold, a full-blown probate case is required. So I often tell a client this: a trust without funded assets is like having a safe with nothing in it. Reason number two, new assets were never added. Even clients who fund their trust initially often forget one thing. Life doesn't stop after signing the documents. People buy new homes, new accounts are opened, they refinance their property, they start businesses, and those new assets never make it into the trust. So years later, the trust is partially funded. Some of those assets avoid probate, others don't. And that partial funding is often worse than no funding at all because families assume everything is covered when it's not. Number three, beneficiary designations override the trust. This one surprises a lot of people. Certain assets pass by beneficiary designation and not by trust terms. So, for example, retirement accounts, life insurance, some payable and death accounts. If the beneficiary designation is outdated, missing, or incorrectly drafted, those assets may not flow into the trust as intended. Worse, if there are no beneficiaries listed, that asset may end up payable to the state, which then is triggering probate. This is why estate planning is more than just drafting documents. It's really about coordination. Reason number four, real estate outside of California. California trusts work well for California property, but if you own real estate in another state and it's not properly titled into your trust, your family may have to face ancillary probate in that other state. It means another court, another set of filings, another layer of expense, and this is especially common with vacation homes, rental properties, inherited out-of-state property. Having a trust can avoid this, but only if the property is handled correctly. Reason number five, a pour-over will does not avoid probate. Most trust-based estate plans include a pour-over will. This is good planning, but here's misunderstanding. A pour-over will does not avoid probate. It simply says assets left outside of the trust should be transferred back into the trust after going through the probate process. So if significant assets are still in your individual name, the pour-over will becomes a document that sends your family in the probate court. This is the safety net, it's the backstop, but it's not the shortcut. Reason number six, incorrect or defective titling. Sometimes assets look like they're in the trust, but legally they're not. Examples include incorrect trust names, missing trustee designations, old trust versions, improper deeds. When title is unclear, financial institutions may refuse to transfer assets without court authority. At that point, probate or court petition becomes unavoidable. And why does this matter? Probate is not just paperwork. In California, probate can mean court supervision, statutory attorney fees, statutory executor's fees, delays that could last months or years, loss of privacy. Basically, it's expensive and it costs a lot and it's not private at all. And the tragedy is this: in many cases, probate was avoidable with little follow through. So how do you reduce the risk? Here's what actually helps. You want to do proper funding. You want regular reviews. You want coordinating between beneficiary designations, updating the plan when assets change, ensuring that title is correct. A trust and estate planning is not a one-time act. It's actually requires quite a bit of maintenance. So having a trust is a great start, but having a properly funded and maintained trust is actually what helps families avoid the probate process. If you already have a trust, This is your reminder to make sure that it still works. If you found this video helpful, please subscribe for more estate planning guidance. I'll see you in the next video.